Good evening, ladies and gentlemen. Welcome to our offices here at Bartier Perry. Thank you for your attendance this evening. For those who don't know me, I'm Dennis Loether. I head up our Planning and Environment team here at Bartier Perry. I'm delighted to have with me some of my colleagues who you'll be hearing from shortly, in particular Melissa Potter in the middle over here, who is the head of our property team, and David Creais from our disputes team. We also have other members of our staff here this evening, Gavin Stewart from our disputes team, and a few other members from our property and planning team, some of whom I'm sure you know. Shortly you'll be hearing from our panellists in relation to this evening's related topics, all of which I'm sure you're very familiar with in your day-to-day work. I'm particularly delighted to have with us Paul Mitchell, and I'll introduce Paul shortly, who will be providing you with an invaluable overview on planning proposals. Following Paul's presentation, we'll be hearing from both Melissa and David. It'll be an interactive question and answer session, so have your questions ready, and I'm sure they'll be happy to answer those questions. We're often asked what is the way to go in terms of what should be in an option agreement. We're often asked a number of questions about how you go about dealing with options, and for that particular reason we've got Melissa and David here, both of whom are very experienced in dealing with the topic. So quite often they can go wrong, as you know, and they'll be on hand to try and answer your questions. Now, before I hand over to our presenters, just some housekeeping duties. Can everyone please have their phones either turned off or on silent, please? In terms of timing, we're first going to hear from Paul. There'll be an opportunity for a few questions at the end of Paul's presentation. We'll then have the interactive question and answer session with Melissa and David, and there'll be a further opportunity for questions after that. Now, we're delighted to once again have our series being live streamed, and for those who couldn't make it here this evening who are following via the live stream, please send through your questions, and I'll endeavour to relay your questions to the relevant presenter. For those in our audience with questions as well, just put your hand up, please. I will have a roving microphone. It's important that you only speak into the microphone so that those who are listening online can actually hear your questions. So now I have the pleasure of introducing our first speaker, Paul Mitchell. Paul's no stranger to Bartier Perry. He recently spoke here on planning proposals, and his presentation was that good we thought we'd invite him here again. Paul's an Australian international leader in town planning. He's managed a number of major local and international consultancy practices. He's a former CEO of Care Australia. He's a president of the International Council of Mining and Metals. He's a state-appointed member of the Sydney Planning Panels, and I'm sure some of you have appeared before him. He's a fellow and former national board member of the Planning Institute of Australia. Paul's prepared planning proposals for residential, commercial and tourism development. He's assessed and determined many planning proposals as a member of the Sydney Planning Panels. He offers wide experience on both sides of the fence. I've been privy to see some of his great work on the panels. And without further ado, I'd like to welcome to the lectern Paul Mitchell.
Okay, well, thanks very much for that kind introduction, Dennis, and thanks everybody for coming along this evening. Look, I note that it's a pretty diverse audience this evening, so I don't tread on anybody's toes. The perspective that I'm taking is the perspective of a panel member, so the Joint Regional Planning Panels or the Sydney Planning Panels as they're now known. And what I'm going to do is briefly run through the background, the context, who does what, the process itself, and things of that nature. Now, I know a number of you will be familiar with this process. I apologise for that, but it's necessary in terms of context. And I just want to, I won't spend a lot of time on that, but for those who don't know, I think it's important that everybody understands what's required and who the key players are. But what I want to focus on is the last parts of the presentation, and that is the risks of planning proposals or rezoning proposals going wrong, rights for appeal and what you can appeal about, who you can appeal to and not, and then to conclude with some do's and don'ts, which I hope are of practical value. So in terms of planning proposals, the whole rezoning process starts with a document that's known as a planning proposal. Now, a planning proposal is a term that has a very wide application. It can be something that seeks to change the zoning of an area, so from, say, industrial to residential or something of that nature, or it can be as simple as changing a provision of a planning instrument like the floor space ratio or the maximum height or something else. So it can be something that's very broad, as I say, or something that's very specific. So for that reason, it's very difficult to generalise about what needs to be in it, how long it's going to take, prospects of change arising and things of that nature. It's also important to note that it's not the whole of the rezoning process. It gets you to a stage called the gateway, and that may or may not be where you end up. It may or may not be close to the end of the process, and we can talk about that later because it's difficult to give generalisations. But the point I'm making here is that a planning proposal is not the whole part of the process, although people often see it that way, and people who get to the gateway often think, well, we're there, and in fact that may not be the case. So important to understand the context. Other important thing to note is that a planning proposal, and what I'm talking about this evening, only applies to changes in local plans, local environmental plans. So if you're seeking a rezoning for a SEP, such as the Sydney West SEP, which covers a large part of the city, important areas like the Bays precinct and other areas of that sort, there is no formal process for that sort of change. Now we can talk about what happens in those circumstances, but note that when I talk about appeal rights and who does what and things of that nature this evening, they only apply to changing LEPs, not SEPs or regional plans, which nowadays are known as deemed SEPs. And then what I want to finish with on this slide is I won't go through it, but just for information, the bottom of the slide says what a planning proposal must contain. So that is defined by administrative procedure. It's not law, it's not part of the regulations, but that's what you have to do when you're preparing a planning proposal. That's the information that must be contained within it. So the next slide is meant to describe the process all up, the approval process getting to the end, the approval or refusal process, and who does what. So the various steps are on the slide. I've talked about a planning proposal. Point to make here is that there are a large number of participants in this process. So a planning proposal is prepared by the organisation or the person wanting to change. So it can be a council. Councils, if they want to change zoning, they have to prepare planning proposals to amend their own instruments for determination, the same as a proponent-initiated or developer-initiated planning proposal. So a wide range of people can prepare them. It doesn't have to be the owner of the land, nor do you have to have landowners' permission to lodge a planning proposal, unlike a DA. So, as I say, a wide range of people can prepare them. You get to the gateway, the minister determines prima facie whether the planning proposal is worthy of advancement or otherwise, and not the conditions, not like a development consent, but the further investigations that you have to undertake to advance your planning proposal for it to progress. So it's a conditional acceptance, but not in the nature of approval conditions. It's the investigations that are necessary. The third step is to undertake those further detailed studies. You've obviously undertaken a lot of investigation in preparing a planning proposal, but inevitably the agencies decide that there's more to do, and the consultation that is prescribed in the gateway approval must also be undertaken. Then there is the assessment and the decision. The assessment's normally undertaken by the council. The acronym RPA applies to the relevant planning authority. So if the council won't do it, the minister appoints somebody else. Typically that's one of the planning panels, the planning panel that applies to the area. The planning panel's role can be varied. It can be taking on responsibility for determination or advising the minister is typically the range of decisions that we're asked to undertake. The IPC is what was formerly known until recently as the PAC, the Planning Assessment Commission, now called the Independent Planning Commission. It undertakes the role typically in the City of Sydney, not elsewhere, but the City of Sydney, where the planning panels would normally do it in other local government areas. And if you're successful in getting through all of those steps, the last is the writing or the making of the actual LEP itself, which is done by the Parliamentary Council. So they're the steps, large number of agencies involved, and the decision making is quite dispersed because of that. Okay, now this is an important thing, and there's an important aspect, and there's quite a number of things that are, I think, not particularly well recognised, or at least from the perspective of people who are hearing these things in terms of the approach that's undertaken, and I'll try to explain what I mean by that. The approval process is quite simple in the sense that there are two sequential steps. The first step is that you must pass what is called the strategic merit test, and the subcategories underneath that are shown on the side. So your planning proposal must be consistent with the regional plan, the district plan, or a precinct plan prepared by the Department of Planning normally, or with a council strategy. But importantly, it's only a council strategy that is endorsed by the Department of Planning, nothing else that the council may have prepared, or where there are changed circumstances. And the changed circumstances are typically new infrastructure that was unanticipated when the LEP was made, or unanticipatedly large or different demographic change. So they're the criteria, and they are the only criteria that are relevant to the strategic test. You must pass the first step before you proceed, and only if you pass do you get to consider what the second stage, which is called the site-specific merit test, and that's the traditional planning items. It's an appropriate development in terms of land use compatibility, the scale of the development, avoids environmental hazards, the infrastructure's good enough, things of that nature. Now, the point that I want to make is that many planning proposals are not responsive. Many planning proposals that I've seen on the Western Sydney Regional Planning Panel and the Sydney Planning Panel more recently are not responsive to that hierarchy. They normally focus on this part of it. So we get lots and lots of glossy designs for new buildings and descriptions of the design history and all of that sort of material, which frankly is irrelevant if you haven't, well, is irrelevant if you haven't gone through the first stage. So that's an important test. That is typically the case, that we would get a presentation that focuses on the design outcomes, how wonderful a new development will be, how wonderful the new buildings will be, but it's not responsive to the key test and the first gateway that you must pass. So I'm happy to take questions or discuss that further if that's of interest when we get into question time. So there are review and appeal rights. So if you're dissatisfied with progress or the decisions that have been taken, there are appeal and review rights that were more extensive and have been made more limited in recent revisions to the rezoning process. So there are two types of appeals, but note they're not a court appeal, they're a review that are available. They are a rezoning review, which is before a proposal goes to the gateway, or secondly, a review of the provisions that are applied to your application, your planning proposal, once it goes through the gateway. Those appeals are undertaken by either the planning panels, appointed as the relevant planning authority, or the Independent Planning Commission if your proposal concerns activity in the City of Sydney. Now, they are undertaken at different times and under different circumstances. So if you want a review or an appeal of a rezoning review, you can do that either if the council says we don't support your application, or if you hear nothing from the council after 90 days. So they're typically the reasons why, and most planning reviews are of rezoning reviews, decisions of the sort that I've taken, not gateways, but there is provision to review your gateway process or your gateway outcome. Now, the appeal must be undertaken within 42 days of the gateway determination, but you must notify the council or the secretariat of the planning panels, the Department of Planning and Environment, of your intention to lodge a planning, a review about your gateway determination within 14 days of that. So a very short period of time in which that occurs. So there you go. So it's quite complicated. There are appeal and review rights. There are two types. They're undertaken by different bodies, different timeframes and different reasons. So you really have to keep on top of these things because the time periods can get away very quickly. What I want to do now is just in the closing 3 slides is talk about some key risks in terms of rezoning refusal, of your planning proposal being refused. I'll then go on to some do's and some don'ts. So the headline point here is that rezoning is challenging, and if you're contemplating trying to get rezoning, you need to recognise that. It's not an easy process. For most of the many years that the Environmental Planning and Assessment Act has been in place, there has been no right of review or appeal about rezonings. So it's only in relatively recent times, the last few years, that there has been a right, and it is something that is regularly challenged by various parties to the process. So it's a challenging process for a variety of reasons, not least of which is the history. And what I've tried to do is to categorise the risks into these 3 groups. The first is merits, and I touched on this earlier on. The point that you've got to get across is that you must pass the strategic merit or the strategic compatibility test. If you don't get through that, it doesn't matter how detailed or how nice your design work is or how much better an outcome you might think your proposal will result in, you won't get anywhere unless you have a strong and credible case for your strategic compatibility. Secondly, there is insufficient infrastructure or services available in the locality. Now, I say this is a key risk because it's very difficult oftentimes when you're doing planning proposals to find out about the capacity of infrastructure, such as the capacity of the train network in Sydney, the water supply, the sewerage system, the bus capacity, the roads, things of that nature. But you need to, because it's a common reason for proposals being knocked off at the latter stages. So very important consideration. Similarly, human services, schools, things of that nature. Now, I don't know what's happened there, but if someone, thank you, David. Okay, so that's the first thing. The merits of the application, they typically fall into those issues. We touch on this further in do's and don'ts. Second thing is errors in the process. Classically, there are 3, and they are on these slides. The strategic merit test is undertaken against the wrong plans. The wrong plans typically are things that a council has produced that are not endorsed by the department. So you go on and on and on about the compatibility with the council's housing study. It's irrelevant if that housing study or urban development program or thing of that nature has not been endorsed by the department. It's a totally irrelevant consideration. So it needs to be against the correct plans. Second point is there is a presumption against change if an LEP is less than 5 years old. So if it's a new LEP, there is a stated presumption against change. So that is another risk. The third is that the planning proposal you lodge must be the one that's assessed. After it has been lodged, you cannot change it. So if you go to the panel and the panel says, look, everything's fine, but it's a 10-storey building and it would be acceptable to us if it was 9.5. We have to throw it out. You cannot change the planning proposal once it has been formally lodged. Now, I can explain why that is the case, but you need to appreciate that that is the case. Now, oftentimes, people will want to fiddle around with these things, not least the planning panel of which I'm a member, but you cannot change them. We can only determine the proposal that is formally lodged with the council at the beginning. Final category of risk is the community. These will be familiar to many of you, but the first point is important. There is not a formal presumption, but there is an expectation if you are zoning, and normally it's an upzoning, that there is some public benefit that is, excuse me, that is formally offered through a voluntary planning agreement. So if there is nothing of that sort, that is often something that is that discredits a planning proposal. If you have an activated community, there's no news to anybody. If you have a very active community that's politically involved, particularly if they're opposed to your proposal, it is obvious that it is going to make it more difficult. So managing the community is an important part of any planning proposal. And always remember that particularly in that latter circumstance where you've got an activated community, that it is very easy to say no, and it is harder to say yes for the body that's determining the thing. Sorry, I've gone the wrong way. Okay, so some do's and some don'ts. Some of these are self-evident, but they need to be said. Some of them are less so. Now, the first and point that I need to emphasise is that you don't go into this lightly, and it is important that you do proper due diligence and you do it thoroughly of the right things. And there's not normally a lot of work in this, but it is surprising to me as a practitioner how often people skip over the fundamental due diligence that should be done and don't find out about it until the very end of the process when they've invested very considerable sums of money and time. You need to look at the strategic merit test. Is there a strategic case? That's not a lot of work to do, but is there a strategic case? You need to answer that question. You need to have a hard look at that. If you haven't got a strategic case, you really should question whether you go ahead. You need to look at whether there are key planning risks. Is the site covered with rare and endangered vegetation or things of that nature? Is there a bushfire risk? Is there a flooding risk? Things of that obvious sort. And also, you need to look at the infrastructure capacity. Is there a situation where you're going to fall over because the train network doesn't have capacity, the road network, things of that nature? So fundamental questions of that nature, it's very important that you look at those at the outset. You'll note that I've said that the basic planning or merit considerations at a local level are not considerations that I think are central to the initial due diligence. The important ones are the ones that I've emphasised. They're obviously relevant factors, but they're not fundamentally important. So once the decision's taken, it's important that you do these things. It's important that you regularly consult with the council. Now that's obviously said many times about development applications and things of that nature, but it is really, really important in this case because of what I mentioned before. You cannot change the planning proposal after it's been lodged. So you need to engage frankly with the council officers. Will you support the application in principle? Is it something that you think has merit? You need that sort of discussion with the council officers because you need to find out whether or not there's going to be a suggestion, look, 10 stories again, it should be 8. You need to have that fundamental agreement to the extent that it is possible about it because you can't change it once it's lodged. So the nature of consultation needs to be good, it needs to be candid. The second point I want to emphasise is this third one. I want to bring that forward. It's important to, if you can, describe the planning proposal in as flexible a terms as possible. Now, obviously you need to describe what you want to do and it has to be accessible, it has to be concrete, but describing it in very precise terms is risky because of the consistency test that I've been harping on about. So where you can incorporate flexibility in terms of what you're trying to do, that is important that is done because it gives you greater flexibility with the consistency test that I've described. It stands to reason, obviously, the third point, second point on the slide, have a credible and correct strategic merit test. I've talked about that. There's no need to go on about that further. And then the others, the fourth point is obvious. You need to do everything that you're required to do. Oftentimes that's not the case, so I've put that in there for completeness. And then finally, another pitfall is that you must distinguish your site from the general situation. A reason why planning proposals quite often don't proceed is because there is a credible risk that it will be a precedent for a general change, for pressure for broader rezoning changes in the locality in which it occurs. In other words, if we rezone your land, why won't the neighbours be able to do the same? So resisting that general risk of a flood of planning proposals is a significant risk to success. So you have to point out why this site and why your proposal is distinctive and why it will not lead to a flood of similar rezoning requests. So then finally, the don'ts, and many of them are self-evident after what I've said. You must consult the key agencies. I appreciate that it's difficult. I appreciate that many of them won't consult until you get to the DA stage, but you need to understand their thinking because they will be their views will be of fundamental importance in terms of the outcome. If the RMS says the road network or the train network is at capacity and your proposal is not incorporated into strategic planning for the area, you're finished. So you need to know about that. So consulting with the key agencies as early as you can or reviewing their information, things of that nature, is fundamentally important. Don't focus on design matters. Now, design is important, but I've said that there tends to be a preponderance of that at the early stages when it is not a key issue. It's obviously relevant, but it's not fundamental. The strategic issues are fundamental at the beginning. Don't assume that because you've got a gateway approval means that you're there. You're not. You've got to do a lot of studies. I've been involved in projects where we've gotten a gateway. People have said, we're there. A classic test or a classic risk is that you discover that you've got to do biodiversity offsets. So you might find out that you've got vegetation there that's important. You say, look, this is what we're going to do, but you haven't done your calculations of biodiversity offsets. And the gateway condition will say from the relevant agency, look, you've got to do this. So things like that can kill a proposal that's got a gateway approval. And the final point is this, and I only say it because this is from personal experience. I've seen this a number of times about poor representation at bodies like the planning panels that are there to make a decision. Don't represent yourselves, and people do that, and do respond to the key questions that the panels are asked to address. So the first thing is the strategic merit test. So you as the applicant need to decide who describes that best. It's often a planner. I'm a planner, so I'm biased, but you're dealing with planners often, so it makes sense to talk about that. You need infrastructure people to talk about the services. You need environmental people to talk about the risks, and that's generally the order that you would do it. And then at the end, you would talk about the design aspects. Too often the situation is inverted, where we're presented with large numbers of wonderful design outcomes that, as I say, are not central to the initial decision that has to be taken. So plan your presentation to be relevant to the questions that the decision makers have to address. That's it. Thank you very much. Do we have any questions about this?
We've got an opportunity for some questions. Does anyone have any questions for Paul? Otherwise we can take...
That's good. I can sit down and listen. Got that? Yep.
Strategic merit test, we read all that. A lot of times the councils who we have problem with them is the public benefits test.
Yeah.
Community concerns outweigh the strategic merits proposal, and they against that is the voluntary planning group, which run voluntary. The concern from an industry viewpoint is how do we address public benefits test when it's not even defined?
Well, you're never going to get around politics, as everybody knows well, and if there is an activated committee, as the term I've used, it makes it more difficult. I mean, that's self-evidently the case. Look, you just need to be aware of what the rules are, and the rules are that there is a strategic merit test, and it's first, and you've got to get through it before you do anything else. And what you're obliged to consider under the strategic merit test is very carefully defined or clearly defined. And anything beyond that is frankly irrelevant. So I think the only thing there is nothing that is going to diminish the risks, where there's community opposition. So to the extent that you can convince your opponents that your proposal is in their interests in the broader public benefit, that helps. And it clearly helps that if you can address the public benefits to a planning proposal, to a planning panel rather, that helps as well. If there are not apparent public benefits, it's more difficult. But, notwithstanding, the key test initially is the strategic merit test, and what you've got to assess proposals against is clearly prescribed. And one of them is not popularity. So, I know that doesn't answer the question and remove the problem, but it's the actual situation.
Do you have any other questions?
Hi, Paul. Sharon Levy from Bartier Perry. Do you have a view on the filing fees, the lodging fees that some councils are charging for a planning proposal? So some are charging over $100,000.
That's it.
Non-refundable.
Look, I know that. Fortunately, I don't have to pay them. And they are huge. And you're right, they are non-refundable, yes. Yeah, and in addition to that, there are the fees that you have to pay the panel if you appeal. So it's an expensive business. That's why I say it's very important, well, it's one of the reasons I say it's very important that you do you don't go into this process lightly, and the initial due diligence is very important, as I think is testing the water as you go along, because you wouldn't lodge, in my opinion, unless you had at least a tacit in principle agreement from the council that what you were presenting was sensible. And then you'd bite the bullet and you do it. But you need to be testing the water as you're going along. As to the cost, I agree, they're very high. They're not prescribed by regulation like DA fees are.
Thank you, Paul. Farah George from Design Cubicle. I took note of what you said about if I've come in for 10 levels and the planning panel says, well, we like 9.5, it's all over. What if it's the other way around? For example, I'm involved in one right now where we've come in at a certain level. Council said, okay, we're all happy with it. Halfway through it, they said, well, how about we reduce it to this and reduce it to that? We said, well, okay, that's no problem. It's just a matter of geographical changes. So the shoe is on the other foot. What's the deal there?
Look, it's the same answer. They're not the law, and it's not even the regulations, but the procedures that are prescribed, the administrative procedures prescribed by the department, and it's in agreement with councils, because the councils, there was a rezoning review that was done a number of years ago. The councils were having difficulty because the proposals that were lodged initially and assessed were continually changing. So the government struck a deal with the councils to say, well, look, it will only be the proposal that is lodged, that is assessed, that goes through. That's the rationale. But it does greatly limit what we can do. So the planning panels used to change these things all the time. We'd say, look, is it so bad that we say no? Is it, good enough as it is? Inevitably, it was neither, and it would be fiddled with by the panel and modified. We can't do that anymore. So the only way around to give yourself more room is to describe the proposal in more general terms, but the caveat there is that it must be sufficiently detailed to be accessible. It's the only suggestion I can make in that regard. Yes, Anna?
Judge Jermaine from City Architects. Today I hear that sort of planning proposals, some councils have actually sort of put a freeze on the planning proposals, such as Kennedy Bankstown and Wright. Do you sort of see that sort of happening more with other councils? And in terms of sort of this grey period where we've got this new sort of... EPA,
Can you keep that near your mouth, please? Thank you.
The new EPA Act coming in,
Yep.
the changes too, so that sort of transitional period between that sort of being implemented. Do you see other councils sort of following this particular trend?
If I understand you correctly, this is changing planning proposals after they're...
No, actually, they're putting a freeze on planning.
Oh, they're putting a freeze on them.
So,
Yes, look, that is happening. In fact, I was in a meeting today where that suggested that will happen, and the minister announced freezes on 2 local government areas. Certainly, that is possible. So it's happening, and that means that it could continue. There is, lots of pressure on areas where the infrastructure is seen as being fully used, and in those circumstances, there is not sense in planning proposals being lodged, and so the councils are deciding, and the minister is obviously supporting them, that planning proposals will not be accepted. Now, the situation is that if a council resolves itself that it won't accept planning proposals, that does not, and the minister hasn't endorsed it, that does not remove your rights to have it reviewed. So if you go to a council, lodge a planning proposal, and I'm aware of situations where they'll say, look, we're not accepting it, right? So, but once it's lodged, 90 days later you have a review right. So it's a different situation if the minister has endorsed it though. Okay?
In the case of Ryde, for example, they've and along with Canterbury, they've said no more planning proposals.
Yeah.
But in lieu of that, they've said they've got to write a new LEP. So if you were going to put in a planning proposal, for example, in Ryde, is there a different process or a similar process where you can not so much influence the LEP on that? Is there a process that we can go through that is similar to a planning proposal where we join in with council as far as creating the new LEP for that particular site where we would have previously put in a planning proposal?
Yeah, look, you should be proactive. I mean, the obvious thing to do is to respond to the draft LEP when it comes out, but oftentimes the horse is bolted. All I can suggest in those circumstances is you put forward a credible submission like a planning proposal, but it wouldn't be one beforehand, to say, look, so you try to demonstrate the merits of what you're doing as input to the planning process. Does that help?
Yeah, so it'd be a similar concept to a planning proposal.
Yes, yeah, look, we think that this area is, the infrastructure can support more development, the site's better used for these reasons, whatever, so you do that proactively rather than reactively once the plans come out. No guarantee it'll be listened to, but that's all you can do. Yes, Anna.
Just on the review and appeal rights,
I don't think that microphone's on, I'm sorry, sir. If it is, I can't hear you.
got to do a Jimmy Barnes.
There should be a red light when it... Okay.
Okay. Just on the review and appeal rights, the 90 days, if council responds within that 90 days, say the 89th day or whatever, does that trigger another 90 days once there's been a response to that, or is that that response from council intended to be determination?
Well, if they respond on the 89th day and say we support your planning proposal, you're not going to appeal, right? So there's only 2 ways they can respond. They can say, well, there's not actually, but they can say, look, we support it, in which case you don't appeal, and secondly, if they say no, well, you do, So the bigger risk, I guess, is if they say we like it, but you need to change it.
Yeah. So request for information.
In that case, I'd be inclined to listen to them and change it and work with them as best you can to achieve an outcome that both parties deem to be acceptable. But it would constitute reasons for a review because they're not accepting your planning proposal. So if they say, if you did this or that, it's not the same proposal, so you have an appeal right.
So maybe can be a no in that case.
Sorry?
A maybe could be a no in that case.
That's right, yes, that's right, yeah.
Okay.
So the maybe is effectively a no if you want to interpret it that way, and you would be grounds for asking for a review.
Right, thanks.
Okay, thanks very much.
Okay, thank you, Paul. And just a reminder for those people who are listening on the live stream, please send through your questions. I am checking, and if those questions come through, I'll pass them on to our presenters. Next part of our session this evening is an interactive question and answer session with our two wonderful presenters from Bartier Perry, Melissa Potter, who heads up our property team, as I mentioned earlier, and David Creais, our chairman, and who heads up our disputes team. And I wanted to first pass over to Melissa. Have your questions ready? I've got one for myself. I'm often working with Melissa on development projects, and I'm often running into office asking her with a question about related to a concerned developer client that I might have, and asking what's the best way for the developer to acquire land, particularly when they haven't got enough time to carry out enough due diligence and they're all stressed about their timing. So she's quite often asked by me what's the best thing to do, particularly if they have plans to develop the site or they might want to go down the path of a planning proposal. So I'd like to welcome Melissa to provide her input on some of the options that are available.
Thanks, Dennis. Sorry? Yep.
You're on.
Hear me. You could enter into a contract like you would normally to buy land with a longer settlement period to allow you to do your due diligence. The risks around that is ensuring that your rights to rescind the contract if the due diligence doesn't throw up what you want are drafted widely enough to allow you to rescind, otherwise you're stuck in a contract and have to proceed to buy the land. You also have to be certain as to who your entity who will hold the land is, because you can't change that once you've entered into a contract, because you'll expose yourself to double duty. And stamp duty will come forward. So stamp duty will be payable within 3 months of entering into the contract. So the means to retain the most flexibility would be to enter into a call option agreement. And that is a commercial agreement that can be drafted to best suit yours and the vendor's needs. You can reserve for yourself the right to lodge a development application, to carry out investigations on the site, to enter the site, to prepare reports. If you're concerned about the land being contaminated, you can reserve the right to drill and test for contamination. It will allow you, if you don't know who your ultimate holding party will be, if it's drafted to make provision for this, it will allow you to nominate another entity or to transfer the purchasing rights to somebody else. It also has the benefit of an option in itself is not subject to stamp duty unless you do nominate another party or transfer that right. Once you start transferring the right under the option, that will attract stamp duty. But if you enter into it and the entity, the option holder will be the ultimate land holder, there will be no stamp duty until the option is exercised, and then you would pay your ad valorem duty as normal. It is a complex document, an option, so it does need some thought and careful consideration. If you're entering into an option to purchase residential land, there are some traps in the Conveyancing Act. The Conveyancing Act will require the option to expressly state that it can't be exercisable within 42 days. and it will also state that the option has to be signed and prepared in counterparts and exchanged. Failure to do that will mean the option's void. So you don't want to do your due diligence, expend money, start to go down that track only to find your options void. Similarly, if it's residential land, the disclosure requirements that relate to any contract for sale apply. And if you haven't complied with those, the option can then become rescindable by the purchaser. So all the other terms of the deal will need to be thought through, such as purchase price, and so a lot of thought needs to go in at the beginning, but then it gives you the time to, as I say, conduct due diligence, and you're not bound to buy. But the vendor has given you an irrevocable offer to sell. The other thing to bear in mind if you enter into an option is when you come to exercise your option, make sure you do it strictly in accordance with the terms. I was reading in the Supreme Court of New South Wales, a judge said, if the option says that it must be exercised by using blue paper and delivered by a man in a clown suit, it won't be enough if it's written on pink paper and delivered by a man in a pixie suit. So what it's saying is, even though the result might be the same, the method to get to that result has to be strictly adhered to. I would only just mention the other benefit with an option, like a contract for sale of land, is it is a caveatable interest. So you can lodge a caveat, and then the title to the land cannot be dealt with in a way that's adverse to your rights under the option. Of course, you pay an option fee that's usually for the benefit of the vendor. If you purchase the land, it will often come off the purchase price, but if you decide not to proceed, well, that's forfeited to the vendor. But sometimes that's a small price to pay if you're not really sure what you're getting involved in.
Okay, so does anyone have any questions for Melissa when dealing with options? Well, as you know, quite often option agreements can go pear-shaped, and that's where David comes into the picture, because that's when we call him in to help us with our problems. So I'd just like David to give us a bit of an overview on his thoughts and comments on when they do go pear-shaped, and to provide some advice for everyone in the room.
Sure. Well, why do they go pear-shaped? I think the start and the finish of it is documentation. As Melissa's just said, it's very important to get all your terms right, to know what you want at the beginning, and it's very important that they're documented properly. Often they're not documented properly. Why? Could be because you're in a hurry, could be because you're trying to save some money, could be because you just don't have the administration to keep that documentation going. And what I mean by that is, it's not unusual, especially if you've got an option over a long period, things change over that period, you might want to renegotiate a term of the option. Now, unless that renegotiation is properly documented, then it may well not be enforceable at the end of the day. As an example, there was a case recently decided in the Supreme Court, case called Carbonian Mills. That was all about, was the option necessary to be exercised before the 4th of September or the 4th of October. The purchaser thought it was the 4th of October and exercised it about the 28th of September. The vendor said no, it had to be done by the 4th of September. As Melissa said, got to follow the terms of the option very strictly, and so the vendor said, I don't have to abide by the option. So what did the purchaser say? The purchaser said, well, before we actually entered into the option, we had a discussion about it, and the agreement we reached was that I would lease the property for 4 years, and at the end of the 4 years I'd have an option to purchase it for a particular price. What actually happened was that when the option agreement was drafted, it said this option is exercisable 4 years from the date it's made, the date it's entered. The purchaser didn't actually get possession of the property, however, for a month. So the option was entered, it was dated the 4th of September, but the purchaser didn't actually get into the property until close to the 4th of October. that put in the purchaser's mind that he had 4 years from the date that he took possession. Not what it said in the document. The upshot of it was that the court said, well, the document says 4th of September. Just reading the document, there's no ambiguity about that. So you can't rely on what was said before you entered into the document. The purchaser said, yeah, but hang on, that wasn't what the agreement really was. The document doesn't reflect what the agreement was. Again, the court said, well, sorry, you're stuck with what it says on its face. So the purchaser said, well, the thing is that after we entered into the option, we had some discussions about it, and if it wasn't already agreed that it would be 4 years from the date of possession, that was certainly the understanding that arose during the course of the discussions we had later. And remember, this is an option that was going over 4 years, so there were several discussions. Problem was, those discussions weren't recorded in writing, and the court said, well, number one, you haven't convinced me on the balance of probabilities, which is the test, that agreement, that variation was actually reached. But in any event, under the Conveyancing Act, Section 54A, disposal of an interest in land has to be in writing. A variation of an agreement to dispose of an interest in land also has to be in writing. That variation wasn't in writing, so if it existed, so you can't rely on it. So poor old Mr. Carvani missed out on the option. So very important to get the documentation right. That's where we see all the problems arising. And in terms of what do you do if you get into that situation where there is an argument over the option, my advice is get yourself into a position where you've got some leverage. Usually that means go and see a lawyer, so a lawyer can throw up some arguments, and then negotiate. And it really applies whether you're a vendor or a purchaser. Try and negotiate an outcome. And remember that as a purchaser, presumably, you've got the property at your option price, which is a reasonable price. It's going to allow you to make a reasonable profit. You might have to eat away a little bit of that profit and offer the vendor a bit more in order to restore the position. But that's always preferable to ending up in court where at the end of the day a judge is going to make a decision. You're not in control of that decision. Judges sometimes get it wrong. That's why we have courts of appeal. But either way, it's going to cost you time and it's going to cost you a lot of money. So that's my advice.
Okay, do you have any questions?
David, what happens in circumstances where you've got an option and the vendor sells the land to someone else? What are you, to another party, what are your remedies that are available?
Mark, that really depends on when you find out.
Right.
Now, of course, the first thing to do is, if you follow the advice of the lawyer, as Melissa said, you put a caveat on the title to the property. That way they can't flog it without you knowing about it. If you haven't done that, though, then if you find out about it before the title actually passes to the purchaser, or the purchaser actually knows about the option, then you'll be able to rush off to the Supreme Court, get an injunction, and you should be able to recover the position because your interest comes first. If, however, it's too late, the land's already been sold, that means the title has actually been registered in the name of the purchaser, and the purchaser has no idea about the option, so they're not tainted with knowledge, then you're stuck with trying to pursue the vendor for damages, and then which means A, the vendor's got to have some money, so you're assuming that when they sold the property it didn't all go to pay the mortgagee, and two, that you can prove what your damage was, which isn't always an easy task because remember you're forecasting, you're basically saying, well, I was going to buy it for 10, it was worth 15, I've lost $5 million, but how do you prove it was actually worth 15 at the time? You might want more. You might say, well, if I'd developed it, then it would have been worth 40 or 50. But you've then got to prove on the balance of probabilities. You've got to convince the court that that was the true value that would have accrued to you, and that was the profit. Because remember, to sell it for 40 or 50 or whatever you're going to sell it for, you've got to incur costs along the way. And we've already heard that the application fees for a proposal are pretty high, so that comes off the top as well.
I'm jumping in, if you take out an option as a developer, go through the expensive process of the planning proposal, spend your $500,000, it's successful, but then you fail to exercise the option correctly. Who gets the benefit of the planning proposal? Does it run with the land in terms of, well, the land has been rezoned, so the vendor can now go off and either develop or sell for a higher price, or does the purchaser, as the developer who spent all the money, have some remedy, even though they haven't exercised the option properly?
Well, that's probably a question for Paul or for Dennis, I think, rather than me.
The answer must be that you're changing the law, you're changing planning instrument. So it applies to everything. So if you haven't secured, you can't secure that benefit to an individual, as far as I can see.
So the purchaser gets the vendor gets the benefit at the cost of to secure your option.
Any other questions? Sounds like everyone's got their house in order in terms of options. Okay, well that concludes the formal part of the presentation. We'd like to thank everyone for your attendance this evening. Please stay around. Our panellists are all happy to take questions and mingle over a couple of drinks. Before we get up there, I would like to announce that our next seminar in this series is taking place on the 16th of August. The topic's about cladding, and we have a couple of building professionals who will be here advising you and also looking at liability issues. It's very topical in light of some recent events, but stay tuned. You'll be receiving notification about that upcoming event on the 16th of August. But otherwise, please hang around for a drink and to mingle and to network. Once again, I'd like to thank Paul Mitchell for attending this evening and for his insights on planning proposals. And I'd also like to thank Melissa and David from our firm for their input in terms of options. Thank you for your attendance this evening once again, and we hope you found that informative. Thank you very much.